Jud B meeting. I know there are going to be some others coming around, so we'll go ahead and get kicked off and get as far as we can, and then we'll have some others join us here shortly. I think Chairman England, so let's put down to 2577. He had that in elections, and we're going to recognize him to be 2577.
Thank you, Mr. Chairman. Ladies and gentlemen, this is a bill we passed out of elections last week. Had some really good questions in there. Chairman Fillingane had some good questions, and we're looking into those. I think we were able to answer most of them, but we did move it out of that committee. What digitization is, if you'll see the definition there on line 10, you may have heard of this as referred to as deep fake, but we took digitization as the definition because Senator Chris Johnson had a bill that used this language, and in order to try to keep it consistent throughout our code, we went with this definition. It means to alter an image or audio in a realistic manner utilizing an image or audio of a person other than the person depicted, computer-generated images or audio, commonly called deep fakes. I think we've all probably seen those at this point in time. They are typically using AI and computer to use make it look like the person is actually involved in an action or saying something, and they can create the voice to where it really looks very genuine. So it's become an issue, obviously, in other areas. Senator Johnson's bill deals with it more from a sextortion or revenge porn type scenario. There was a young lady in New Jersey, I think, that some of her classmates digitized her image and made it look like she was doing something she was not. It's also become an issue in our political campaigns, which is why we've got this bill out of election. In order to be a digitization, again, it has to be an image or an audio that's used in a realistic manner. So we're not talking about cartoons or anything like that. So I think Marshall Ramsey would still be able to do his good depictions of all of us that he does, that some of us are cool with and some not. But it would be a reasonable person would have to believe it depicts the speech or the conduct of the individual, and the production has to have been substantially dependent on technical means. So again, this is computer AI type generated. You'll see some other definitions there if you want to take some time to look through them, and I'll be happy to discuss if you'd like to. Part 2 of this bill is what actually describes what the cause is. It's when a person disseminates a digitization or enters into a contract or agreement to disseminate a digitization, they're guilty of a crime as provided in subsection 3. The digitization must take place. You'll see takes place within 90 days of an election. It is disseminated without the consent of the depicted individual, and it is disseminated with the intent to injure a candidate or to influence the results of an election or to deter a person from voting. So those are the three parts that we have a problem with digitization here that we're trying to address with this statute or with this bill. A person convicted under subsection 3 there talks about if the violation is committed with an intent to incite or cause violence or cause bodily harm or to deter a person from voting, which is obviously a very serious issue, they will be, or if they've been previously convicted under this code, they can be sentenced for up to 5 years and a payment of not more than $10,000. In other cases, it's up to 1 year and up to $5,000. The cause of action, so who may bring this, is listed in subsection 4. You'll see that as the Attorney General, the District Attorney, the depicted individual, the candidate who is either injured or likely to be injured by the dissemination, or a political party can bring the action. And I want to point that out because Chairman Fillingane had a very good question in our elections committee meeting about what if, if I was running for an election and Joe Biden came out, or there was a depiction of Joe Biden saying, hey, I support Jeremy England. Well, that might hurt me, but also Joe Biden wouldn't likely to want to do that. And if he didn't say that, he could bring the action or I could bring the action. So that's just to make that clear that it doesn't have to be the person involved in the campaign. It can also be the depicted individual. Also, has to be clear and prominent language. Display, or it's a defense if you have clear and prominent image or language throughout the ad that says, you know, this is a digitization, this is not the real person. That is a defense. And I should have mentioned this before, you've got a committee substitute for this bill, and I realized that when I got to the last little part of this, because we have added language. And if I can find it here in our packet, I will jump to that for you. Let's see, 2577. Do we have that here? Okay, before my bill. Okay, thank you. Okay, so Ethan's just told me it's immediately before my bill, so I had just jumped too far ahead in my packet there. The part that is added is subsection 6, which we see in a lot of our different bills now that are dealing with digitization and things that are being put online and maybe use Facebook or television or anything like that. This provides a defense to the people who are that platform. So in other words, Facebook or ABC or NBC or any of those individuals, they aren't the ones that are being held accountable here. They are just, you know, basically the platform. These are the bad actors we're after here that do that. You'll also see a question that I've got is on line 100. If a content constitutes satire or parody, it's not included in this. So we're not after the SNLs of the world. And you'll also, if you'll jump back, I should have mentioned this before. If somebody's doing a parody and dressing like somebody or something like that, again, on SNL, that's not included on this. Again, these are digital images that have used technology to depict somebody that's not them or in an action that's not them doing that. Or audio, it can be a radio ad, and if it's not that individual. So that's I guess probably a longer explanation of the bill that was needed, but I hope it has explained it well, and I'm happy to answer any questions. Yes.
Great explanation. Questions by the committee members for Chairman England? Senator Sparks.
Thank you, Mr. Chairman. Thank you, Senator. One thing, if this bill passes out, is before we get on the floor, I do think we need to look at the language. A cause of action may be brought by. This is actually a criminal statute. And I think a cause of action may be brought by sounds a lot like a civil statute, because there's still going to have to be an affidavit filed by the aggrieved party and presentation to the grand jury. So I'd be glad to work with you on that, but I do need to make sure that we've got it written in a proper criminal form.
Absolutely, and I would definitely like to look at that. Of course, this would be a cause of action for an injunctive relief, but being somebody that does not practice in criminal law, I do want to make sure that we address the cause of action, who may bring the suit properly. So I'd love to get with you on that and make sure we've got that good for the floor. Thank you, Senator Clark.
Not for a motion.
Title sufficient, do pass committee sub.
For the motion, all in favor say aye.
Aye.
Opposed, nay. The ayes have it. Thank you, Chairman England, for that. We'll bump up one. We have Chairman McMahon with us, who has joined us. He is the chairman of the Municipalities Committee. There's a Municipalities Double Referred Bill on homeless encampments, Senate Bill 2500. I believe we do have a committee substitute on that one. Is it in the packet? Yes, it's one of the loose ones you may have, so you want to check out the proposed committee substitute. So I'll recognize Senator McMahon to explain what his bill does, and then I'll get Ethan to explain the few changes between that original version and our committee substitute. Chairman McMahon?
Thank you, Mr. Chairman. What we're trying to do is we're trying to give municipalities another tool in their toolbox here in Mississippi. And this is not going to affect every municipality. It's going to be offered to every municipality, but what we're trying to do is give municipalities the ability to deal with some homeless encampments when they're discovered on private property. And so we're going to add homeless encampments to the code section, but the real change in the legislation would be on lines 231. And what it would do is if a governing board chose to go on private property by invitation, it's got to be an invitation of the landowner. But if the board chose to go on the property and clean it up, they could mitigate the fee and not charge the landowner to clean up the property. What is happening in some areas, homeless encampments are being discovered and they're already trespassing. So, of course, authorities can go in and remove them. but they cannot clean up the cesspool, the temporary structures, anything like that that's left behind. So that's what this bill would do. It would allow cities to mitigate that. Now, Senator Hickman's not here, but he had a really good amendment that we're going to consider that we said we would do on the floor unless your committee sub addresses it. But Senator Hickman really had a good idea. He said that it's the board should announce at the beginning of their budgetary process each year and identify how much money that they're going to put aside for this and promulgate rules for it. And I like that amendment. I do like that amendment. It's not in this bill, but I would yield for any questions.
First, I'm going to ask Ethan if he will to, in addition to your very good explanation, to add what it is that the committee substitute has that was different from your original bill. Ethan?
Sure. There are two main things. The language is very, very similar in section 1, but if you go to the committee sub on lines 66 through 70, it mentions that the convictions under the misdemeanors there will not appear on the person's public record. And then if you turn over to lines 74 through 87 or so, it has spelled out the notice that's given, and it requires notice of certain mental health services before action is taken to abate the nuisance. And then the only other change that's significant is in the second section, and it just kind of conforms with what Senator McMahon was doing on lines 347 through 350. It says that any cleanup, the decision to remove a homeless encampment on private property shall be discretionary by the governing authorities of the municipality. And I think what Senator McMahon was saying there would be a good place to put that language.
I wouldn't resist that. The one thing I would like, if this committee decides to adopt the committee sub, if we go with the original language, we can put those in there on the floor, a committee sub, or I would like to put a reverse repeater in this as well because it's a work in process. I've met with the MML. I've meeting with some mayors from across the state. My House counterpart, he and I have had multiple conversations about it. So we would like to add that before we bring back a finished product, if the committee would consider that.
Senator Chairman Barnett.
Thank you, Mr. Chairman. Senator McMahon, you being a former councilman, I've been a former mayor, you know, there was laws that was created some years ago that said that cities could notify individuals by letter 3 times before they would actually go in and tear down old property, clean up old property, and then assess those fees to that individual taxes so that the city wouldn't be on the hook for what it costs for the cleanup.
That's correct.
So my question is there any kind of consideration? Because what I'm seeing here is that if the cities decide to do this, then 100% of the cleanup will be on the taxpayers. Is that correct?
No, it wouldn't. This would only deal with the homeless encampments. It would not deal with blighted property.
I understand that, but what I'm saying, even if it's on the homeless encampments, there's still a cost that's going to be passed on to the city and therefore to the taxpayers if nobody else is paying for this cleanup. Is that correct?
Ask me that question again. I want to think that through.
Even if this is for a homeless encampment, and if the city chooses to clean this property up, 100% of the cost is going to be incurred by the city and the taxpayers.
Well, this would be an invitation by the landowner to come onto the property and clean up the property.
Understand that, but I'm just talking about even if you have an agreement with the city for them to announce it in the budget, but 100% of this will be paid for by the city and the taxpayers. Is that correct?
If the governing board voted by unanimous consent to address it as a homeless encampment, it will not deal with blighted property. For example, I'm a former Congressman,
what you're saying.
A former alderman.
We're just talking about the homeless encampment here that this bill is addressed.
Yes. Okay. And there's a limit on what, there's a limit on what you can assess a property. if you go in and clean it up. We deal with that just like you do, just like you did when you were mayor. We had to deal with that sometimes. People abandon their property and we'd have to go in and clean it up and assess it to their tax roll. And that would still be one of the tools. This is just another piece of that, another tool.
So if it's on the property, the private property part, would this still be assessed to that individual property taxes, or would this be the cost that the city would have to incur?
That would be up to the board. That's what we're offering, to allow the board. And see, a lot of cities are not going to have a fund. They don't have any extra funds for this. But I'm not looking for the perfect bill. I'm looking for a good bill to help the cities that do have the funds available. And I did, to answer your question, you and I both represented small municipalities. There was a companion bill to this that allowed for a loan and grant program to small cities that did not have funding. But I don't know that bill is going to be taken up and financed.
Okay, well, as this bill moves along, and you said it's a working process.
It is.
You all really consider that as an option so that cities don't have to foot the whole bill, or find a way so that the taxpayers don't have to have an extra burden on them by doing that?
This bill doesn't take that away. They may waive it. There's still a $10,000 assessment in the original law.
Thank you, Senator.
Yeah, and look, as a former mayor and as my senatorial colleague, I would welcome any input that you have to share on this, Senator. It'd be helpful.
Thank you, Senator May. Thank you, Mr. Chairman.
You both. Senator Hill.
Thank you, Mr. Chairman. I was just going to reiterate that it says that the penalty may be waived in the discretion of the municipality. It's not that they're going to pay for every single cleanup that they wind up doing. But my thoughts are there's some properties that are so tied up with heirs that nothing legitimately can be done as far as collecting anything. And that goes on for years and years and years. And I can see a scenario where it would certainly be in the best interest of a municipality if there was a homeless encampment and property was tied up like that it would definitely probably be in the best interest of the city to clean it up.
And Senator, to answer your question, if there's a blighted property, the city, and it's tied up with heirs or someone that lives they can still go in and clean up and still assess.
Right.
And that happens every day. There are some properties that are assessed $2,500 a year, and they'll have $25,000 in tax assessments if they sell the
right.
property.
But the only thing we're talking about potentially waiving is cleaning up a homeless encampment, not blighted property.
That's correct. That's correct.
I think this could potentially help municipalities.
Yeah, it will help. It's just another tool for the board, to allow the local board to govern.
Okay, other questions? Those are all good ones. I think then Chairman McMahon had advocated for a reverse repealer.
Whichever version this committee would choose to adopt, if you would choose to adopt one at all, I would ask that a reverse repealer be put in it so that we can continue the conversation, and that both chambers and everybody that has ownership in this bill will feel good about it, or we won't pass it.
Okay, Senator Hill.
I believe if we put a reverse repealer in, it would have to go back to municipalities, correct?
Even if you adopt committee substitute, it's going to have to.
Okay.
Correct.
Okay.
That's right. If you adopt the city, I'm palatable to either one, whatever the will of the committee.
I would offer a reverse repealer then for the committee's consideration. Any questions? If not, all in favor say aye.
Well,
any opposed, nay. The ayes have it. For a motion, not sufficient to pass committee substitute. All in favor say aye. Any opposed, nay. The ayes have it. Thank you so much.
Mr. Chairman, municipalities will meet this afternoon at 5. If you will report that bill out. Thank you.
Thank you, sir.
Thank you, Senators.
All right. We have Commissioner Tyndall, who has patiently waited through 2 committee meetings to be able to present to us a couple of bills that impact his department. So please pull up a chair and a microphone, Commissioner. I think your first one maybe is Senate Bill 2180. And that's ours. Let me take that back. That is our bill. We're going to call that one up. The only thing I believe this one does, and Ms. Robertson can keep me straight if I get a skew here, is this removes the petition where you have to seek permission to do a public protest. That was in the original bill last year. Like if you're going to protest in front of the governor's mansion or something like that, there was a petition that you had to make in order to get authority essentially to have a public protest. I've heard from quite a number of people that thinks that's probably unconstitutional. I think it's tied up in litigation potentially, and we're certainly set to lose that litigation if we pursue that. I believe so. To sort of streamline that, we were just going to try to pass this bill that removed the prior written approval for that. So that's then the committee substitute. Were there any other? Oh, yes. And the second piece of that is within the footprint of the CCID, the Department of Public Safety currently is not allowed to enforce any of the city's ordinances. And so if they're going to be responsible for going in there and receiving all the phone calls, which Commissioner Tyndall can speak to, I think the way it's currently set up, if someone calls about anything within the CCID, those calls are all being routed, as I understand it, to the Department of Public Safety. And so if there are issues dealing with code enforcement that they need to address based on those calls, currently they don't have any authority to address any of those issues related to code enforcement within the city. So this bill would give them the authority to address those issues also. I believe those are the only two issues in 2180. And Commissioner, would you like to speak to whether that happens or goes on as far as the calls y'all receive?
So one of the challenges, I think, for Capitol Police when it comes to enforcing municipal ordinances is which ones this body would want them to enforce. You're talking about code enforcement and, you know, building codes and things of that nature. We're certainly not equipped to handle that. But there are other municipal ordinances, vagrancy and such, that maybe this committee would want us to be able to have an impact in. So I'm sure we'll continue to look at that as it makes its way through the progress of this session and maybe get down in the details of which ordinances, the types of ordinances y'all want us to handle.
I'm curious, do y'all receive those as far as the routing? Because I think this was a question last session when we were talking about this. When a call comes in from someone within the footprint of the Capitol Complex Improvement District, where do those calls go, and are they routed to you guys, or how does that work?
So they go to the 911 call center if it's a 911 call. And it is geofenced in a manner in which they'll generally know where the call's coming from and where the request for service needs to be. And if it's within the CCID, they will forward those calls to our dispatchers, and then we'll send somebody. I think it's by July 1st of this year. We're hopeful that we're going to have our own 911 call center established. Might take a little longer. We're working on trying to get it done, but we're having to coordinate with the services here in Jackson and Hinds County, and a lot of minutia going through all those details. But we're hopeful to have that up by then.
And I know you've been working collaboratively with the city police departments and the chief and even the county sheriffs as well. How's that going?
I think it's going well. Obviously, we just announced 3 weeks ago Operation Unified, where the city of Jackson, Hinds County, Department of Public Safety, and federal law enforcement partners were coming together trying to get a lot of the illegal guns that are on the streets off the streets, as well as have a concentrated effort of doing a task force within the city. And the name says it all. Operation Unified is a unified effort of all the law enforcement agencies that operate within the city of Jackson. So that's going well. I've got a meeting with Chief Wade Wednesday. And so we are moving forward and having conversations and trying to work together as law enforcement community.
Well, thank you for your efforts. I really appreciate that. All right, questions on 2180? If not, for a motion, title sufficient to pass committee substitute. All in favor say aye. Any opposed, nay. The ayes have it. All right, we're going to go on now to 2179, and we will recognize Commissioner Tyndall for an explanation.
And Mr. Chairman, did we do a committee substitute on this particular? I see it. Okay. All right. Section 1 essentially gives us authority in the new headquarters building to lease space to the Troopers Credit Union. The credit union has operated at our current headquarters for years, but we've never had any sort of formal lease agreement with them. So this gives us that authority to do so. And we also have a bill in the House that does the same thing. And I think on the committee substitute, I think some of that language we looked at changing to mirror kind of what was in the House coming from that side. I think section 2, we talked about taking that out. And this year not setting up any special funds for it. We won't be in there for another year, year and a half, so we'll actually deal with that when it gets here. Thank you. Sorry, I was looking at another version. All right, then section 2, as it stands, highway patrol agents and MBN agents that work at the Department of Public Safety, whenever they retired or if they were killed in the line of duty, they were able to either keep or their family was able to keep their service weapon. This just extends that to all members of law enforcement that work at the Department of Public Safety. So our Capitol Police or CTED would fall under the same purviews. Section 3 sets up a medical examiner's office task force. One of the challenges I've had being at the department is dealing with the medical examiner's office. We've had a lot of great improvements. I think some of that's been well documented. When we got there, we had a backlog of over 2,000 cases that dated back to 2010 of autopsy reports that had not been completed. One of the biggest challenges that I face is trying to recruit forensic pathologists to come to our state. UMMC does not have a board-certified forensic pathology program, so we're trying to recruit people to come into this state, and I need help from these folks telling me how best to improve the medical examiner's office and offer recommendations to y'all as a body on legislation that could help improve that, not just for today, but for the future. So that is what Section 3 does. It does have a repealer in it. I think once the board is met and make those recommendations, we'll consider whether or not that board needs to continue. Section 4 is a DUI law. Really the only thing that it changes, a couple of years ago, non-adjudication was added for DUI other because there was no point in having a intoxilizer in a car for somebody that wasn't charged with a DUI dealing with alcohol. But what we needed to make clear is that they would have some sort of suspended or restricted license during that 120 days. And so what this does is if you plead guilty to a DUI other, your license will still have some sort of restriction on it for 120 days. And that helps protect our federal funding that we receive for being in compliance with these DUI requirements. And that's the only change in that section. And then section 5. Is language dealing with forfeitures. It requires that we're given notice as well as the AG's office on forfeitures that are done through the state. And that's really the only change there. And in section 6, deals with the medical examiner's office. Again, as it stands now, there's a council that meets. The task force would really take the place of that council, so it just deletes the language that establishes the medical examiner's council, and then we can reenact in that after the task force is able to make recommendations. So that's the explanation of Senate Bill 2179.
All right, Senator Suber.
Thank you, Mr. Chairman. Mr. Tindall, going back to lines 477, 478, 479, about the restricted license or the DUI other. You know, now if someone has a restricted license, I think an officer pretty much understands there's an interlock or something in the vehicle. How are you going to distinguish that with, you know, someone who's just doing the drug test?
Right, and I think we'd have to come up with something on the restricted license that identifies that they're under a DUI conviction, that it's restricted for certain purposes during that 120 days. And so part of the problem that we have is, again, I think a lot of attorneys have realized they can plead somebody to DUI other instead of DUI with alcohol. And so in turn, their clients aren't getting a suspended license at all. And so they're kind of working their way around instead of, and so basically they have no restrictions or anything. And so this makes it clear that we got to offer some sort of restricted license for those individuals that plead to a DUI other.
Well, because under the DUI alcohol, and you've got the intoxilizer in your vehicle or the little machine, you know, that's really the only vehicle you can drive if it doesn't have it in there. And you know, what would be a point of a restricted license if they're doing the drug test?
Well, they're doing the drug test.
They would be able to drive any vehicle they wanted.
Right. So what's happening, if somebody gets charged with a DUI, let's say 0.12, 0.20, 0.16, so they're coming in and they realize, okay, maybe I can plead to DUI other. Right. And then I just had to show up for a drug test, which I'm not using drugs anyway, and I don't have any sort of restricted license that, and again, it puts our funding in jeopardy if nobody's facing any sort of restricted or suspended license. So the restricted license probably needs to be very clear that you're in a drug testing program, and that you're only using your vehicle for certain purposes during that time, since you don't have an interlock license.
I'm not going to say I haven't had a client do that, but thank you.
And maybe you should, right? All right, Senator Sparks.
Thank you, Mr. Chairman. I'm not going to beat a dead horse on this, but the term in lieu of suspension is what we're operating under. If someone has an other substance, DUI, there isn't a restriction. The in lieu of is to be tested, and that's up to the court. And if someone is pleading guilty under the facts and circumstances, that's up to the judge. If the ticket's amended, it'd have to be amended. So I respectfully on this one, I'm fine with it going right now, but I very much disagree with the language to make it a restricted license on an other substance DUI. Over 50% of DUIs now are other substance, I believe is what the data shows. The issue is nobody's having to pay a reinstatement fee. So I'm just want to be honest with you that we need to work on that language if we can, Commissioner.
I'll gladly work for a solution. I mean, obviously we got to have some sort of restrictions on there. And again, I think as good defense attorneys and those in the courtroom have realized, I mean, you can plead to a DUI other, and maybe it is alcohol, maybe it's not. It's just whether or not you were inebriated and you went through a test, and the officer will testify to it.
Well, I'll respectfully also point out that as long as we're going to let law enforcement check all 4 boxes on a ticket, who's to say which part makes you DUI? And the court has ruled that you're DUI, and they don't have to prove it's alcohol or drugs. So I don't want to.
But I do think we can, if you've got some ideas on ways we can tighten it up, I mean, I certainly think that's something we ought to look at doing, and I understand what you're saying, and again, you know, it's making sure that everybody's treated the same. Whether I was here when we did the non-adjudication and the intoxilizers in the car, and I think it was a good bill and it was the right thing to do. You know, and then it came along that, well, what about people with other substances, and maybe they deserve an opportunity to have a non-adjudication and be able to drive and go to work too. So we need to figure it out, but I also want to close the loophole.
Well, if NHTSA has offered a letter stating we're going to lose funding, I'd like to see it.
I don't think they have, and they won't.
Okay, thank you.
Senator Hill.
Just a comment, whether it's DUI or DUI other, impaired driving is impaired driving. It's not apples and oranges, it's apples and apples. So I think I can see where the commissioner's going, whether we need to continue to work on the exact way to do it, but I don't think anybody ought to get a pass. Thank you.
All right, any other questions? All right, for a motion on the bill? I'll make it title sufficient to pass. What is this, committee substitute? All in favor say aye. Any opposed, nay? The ayes have it. Thank y'all for the discussion on that one. Commissioner Tindall, is 2286 also in your purview?
Yes.
All right, you'll recognize for 2286.
Thank you, Mr. Chairman. Senate Bill 2286, I believe there was a committee substitute as well. In essence, what we're doing, whether it's the committee substitute or the original bill, is we're wanting to revise the makeup of the Board of Law Enforcement Officers Standards and Training. And we're going to continue to work on the makeup of that board as the bill makes its way through the session. I imagine there'll be several different variations as people are added or taken off. But what we really wanted to do is get the focus of that board being back towards being law enforcement officers and those with a criminal justice or law enforcement background. As it stands now, I think the Municipal League and the Board of Supervisors Association had appointments. There was, I think, a professor that was supposed to be on there. And again, we're trying to get it back to being law enforcement officers with a law enforcement focus. The other part of the bill that we'd like to do is make it clear that the board itself can conduct investigations on its own. Typically, when there's a complaint against a law enforcement officer or a reason to bring that law enforcement officer certification before the board and call it into question, it comes from a sheriff or police chief that reports that when they're terminated. What we would like to do is make it clear that the board on its own can go out and conduct investigations. And in essence, I see it being much like the judicial performance, the bar, the medical board, where they can self-investigate from a licensing standpoint and do their own investigations into individuals based upon public complaints or information from other law enforcement officers or chiefs or sheriffs, as the case may be. So that's the other change in the bill. I do think the committee substitute makes it clear that the Police Chiefs Association has an appointment. In the past, it's just said the chiefs or a member of the police chiefs, but that it would be coming from the Police Chiefs Association would have a representative on the board. And that's an explanation of the bill, and be glad to answer any questions about it.
All right, any questions? Thank you for the explanation, Mr. Barnett.
Thank you, Mr. Chairman. Thank you, Mr. Commissioner. I think this is a good bill, but I have a question in regards to not just the board, but we talked about the board investigating its own. Is there any consideration going forward to where if an individual is moving from department to department, and that individual is not truthful as to why he or she left A department to go to B department, is there anywhere in the bill that holds them accountable? And is there anywhere in the bill that may hold an agency accountable for not reporting that this individual was a bad actor before and not letting another agency know that, so that we don't have some of the problems that we're having now with our law enforcement?
And that is a big issue that a lot of law enforcement officers have brought to my attention is individuals that go from agency to agency and it's not reported, or for whatever reason they're reinstated. And so I think we can look at strengthening that part of it if the legislature wants to dive into that. It certainly makes sense, and I think that but I want to also be careful and not, again, I go back to, it's my belief that 99.5% of all law enforcement officers and leadership do it for the right reasons, and they're trying their best to do the best job they can. And I don't want to put good officers or good departments in harm's way if they make a mistake, or if there's a judgment call made on an officer, hey, I want to give this guy another chance. I think sometimes those things are warranted. And I think the board needs the freedom to kind of make those decisions, and the agencies need the freedom to make those decisions. But I certainly believe that we can tighten that up and have a little bit more teeth into the reporting requirements, and then the self-certification as far as if somebody is trying to get reinstated and report themselves of any misconduct. I mean, you kind of have to do that, I think, as a lawyer. Self-report, and maybe we need an avenue for that as well.
Thank you, Commissioner. I'm not trying to hurt any departments. I have a lot of friends that are in law enforcement, so municipal to county, even to the state level. But I just think we need to look at ways of making sure that not only do we protect and serve, but we really protect and serve. To make sure that the public is getting the best officers out there, to make sure that those things are happening, so that municipalities and counties and even the state of Mississippi are not being sued over lawsuits for the bad actors that's out there. So I'm just asking, going forward, even with this bill or maybe some other legislation going forward, would there be some consideration making sure that we can protect in those areas.
Yes, sir. And what I really want to do is protect, again, the 99.5% of law enforcement officers that are making the sacrifice to keep our community safe and make sure that bad actors don't ruin their reputation in the process. I'm with you.
Thank you, Mr. Commissioner. Thank you, Mr. Chairman.
Thank you for your work on that. I know you've been at the forefront of trying to bring that issue forward to make sure everyone's treated well and fairly, and that's what we should all be about. So thank you, Chairman Barnett, for your work on that. All right, any other questions on the legislation? Senator Hill, did you? No. All right, anybody else? Don't want to leave anybody out. All right, for a motion. Thank you. It's just do pass on this one. All right, thank you, Senator Sparks. You've heard the motion. All in favor, say aye. Aye. Any opposed, nay? The ayes have it. All right, let's bump down to the very last one on the list. Not the last one we'll take up, but Senator Sparks has the explanation on 2599. Thank you, Commissioner Tindall.
Thank you, Mr. Chairman. Senate Bill 2599 addresses alternative incarceration methodologies, which would include a RID-style program. We used to have a program that was regimented inmate discipline. It was an incarceration sentence, but it could be non-adjudicated. In talking with our judges and the district attorney's office and the attorneys across the state, there's kind of a gap between sentencing someone to MDOC custody and putting them on probation. This is actually an incarceration sentence that may deal with lower level felony crimes, potentially nonviolent crimes, and I think it's a program that may be able to be put together to be beneficial. At this time, these are the code sections that are brought forward for the purpose of that. So there is no new law in these code sections at this point. That's an explanation of Senate Bill 2599, Mr. Chairman.
Thank you. Questions for Chairman Sparks? Not for motion?
Title sufficient, do pass.
You've heard the motion. All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. I don't want to put Senator Suber on the spot, so we can bump over this if we need to, but 2651 is I think was originally said to Wildlife, Fisheries, and Parks. You authored the bill. Would you like to go ahead and explain it now, or do you want some time?
No, it's fine.
All right.
Thank you, Mr. Chairman.
Yes, sir.
What this bill does, the law currently states that no one can enter the land on another, hunt and fish, shoot, after being told they can't. So you have to be basically warned for the first time. So this is just stating that it's just unlawful to enter the land on another, to hunt, fish, and shoot. And basically what I did in line 17, 18 is I just mirrored the trespassing statute, just basically the same fines, penalties. But in section 3, it just makes a subsequent offense where you can forfeit all your hunting and trapping, fishing privileges for a period of 1 year. Line 4 just allows law enforcement to seize any, or makes it a violation, and they can actually seize any of the fish, any animal parts, or, deer, or anything like that. And in section 5 here, lines 29 through 34, just adds can add an additional penalty for each bird or fish or something that was that they received or that they caught or anything on the property of another. And section 6 and 7, basically the fees are to be sent to the state treasurer, and section 7 that it have to be appropriated by the legislature, any of the monies. I'll be happy to answer any questions.
I have just one. I get calls from time to time, I'm sure others do too, about dog hunting. Does this bill affect people hunting with dogs in any way?
I don't think so. This is basically just anybody trespassing on your property.
Gotcha. So if the dog goes onto the property, we're not talking about it being a trespass, just if the person hunting goes on the property?
I don't think so. I mean, I think you still have to knowingly go onto a property, and I don't know that a dog can knowingly go onto a property.
Just curious. All right. Any other questions for Senator Suber? If not, for motion?
Committee sub.
Heard the motion. Title sufficient do pass. Committee substitute. All in favor say aye. Any opposed, nay? If the ayes have it, I think. Okay, the ayes have it. All right. Thank you, Senator Suber, for letting me put you on the spot there. All right, let's go back up to, I don't think Senator Simmons is, he hasn't joined us, has he? He's got the first bill. Let's go to Senator Barrett. You have 2606. This one was, I guess, reconsideration was the motion on that one. So are you ready to take that back up? All right, we recognize.
Thank you, Mr. Chairman. I would ask that the motion to reconsider be disposed of or tabled at this time, Mr. Chairman.
Speak to that.
Certainly. Again, my bill is specifically to allow very narrowly focused. It passed 119-0 in the House on the floor, and it is focused on minors that are charged in circuit court with aggravated DUI. If you are charged in adult court, you should be held to the adult standard, i.e. 0.08 as opposed to 0.02. I would ask that the motion to reconsider be tabled, Mr. Chairman, and I'll yield for question.
Right. Yeah, Senator Sparks has a question.
Thank you, Mr. Chairman. Senator, two things on this. One is I would like to offer a reverse repealer because I think that this will help us get the information that was, if that's a friendly amendment.
No objection.
That would allow us to get the information we need. But I also think it brings us right back to the point made earlier about DUI other substance.
Right.
Is DUI other substance, I get treated the same as an adult if I'm a minor. So if it's DUI causing death, DUI felony, and it's considered marijuana or it's considered some other substance, as a minor, I get the same defense as an adult would.
Right.
And all you're trying to do with this is to say if it relates to alcohol in a felony case that you could go to prison, that you get that same reading. Is that correct?
That's correct.
Thank you.
Thank you.
Any other questions? If not, for motion, well, the motion is to table. Procedurally, how we do that?
I think you table it,
You
and
have
then
to
you have
table.
to reconsider it. Pass it.
All right.
Or,
Okay. So the current motion in front of the committee is to table the motion to reconsider. All in favor, say aye.
Aye.
The ayes have it. So it has been tabled. Would anyone like to do anything else with it here? Senator. No, I don't think you can do that on a, we can do it on the floor if y'all prefer. Okay, all right.
Yes, sir. Thank you.
Thank y'all. All right, going down to 2174. The next two bills we passed out last year, and as sometimes happens, at the other end of the chamber didn't see fit to get them all the way through, but this first one deals with the motor vehicle theft. It's currently punished as a crime of larceny based on the value of the stolen vehicle. What this bill would do, it provides that the crime will be a felony, a fine not more than $10,000, or imprisoned in MDOC for a term not less than 5 years, but not more than 20 years, or both. The restitution amount of damages and reasonable repair cost, and a second or subsequent offense, a fine of not more than $20,000, or imprisonment for a term not less than 10 years, no more than 40, or both. That's what 2174 is about. Any questions? Not for motion titles to pass. All in favor say aye. Any opposed, nay. The ayes have it. 2175, receiving stolen property. Again, this is a repeat from last year. The current law retains that a person commits the crime of receiving stolen property if he intentionally possesses, receives, retains, or disposes of the stolen property, knowing that it has in fact been stolen or having reasonable grounds to believe it has been stolen. The stolen motor vehicle has historically been included in definition of stolen property, but the prosecutors sometimes have a hard time proving the value of the vehicle. I think there's a creation of a section specifically for stolen motor vehicles. The fine is, or the punishment, not less than 5 years, not more than 20 years. and or a fine of not more than 10,000 or both. And it places a minimum sentence on possession of stolen property of over $25,000 in value, not less than 5 years, no more than 20 years, or a fine of not more than 10,000 or both. Okay. I may have reversed the bill numbers. Maybe. Okay. Any questions about this one? If not for motion, you've heard the motion. Title please do pass. All in favor say aye. Any opposed, nay? I wanted to ask Marty Milstead. I mean, the reason he was so patiently waiting is I think we've recently had some evidence of some of these crimes being more pronounced or prevalent in our area. Would you mind just telling us from the automobile dealer's perspective, is this something that's happening more and more or not?
Thank you, Mr. Chairman, the committee. Yes, sir. We have had more and more automobile thefts at dealerships as recently as week before last in Laurel, Mississippi, Senator Barnett, close to your neck of the woods, where what's happening is these thieves are going in, taking crowbars, whatever, just busting into the dealerships. They'll go through the front doors. They start looking for keys. This happened last August. One night in Brookhaven at a Chevy dealership, the next night in Vicksburg, and then they went back to Paul Barnett Nissan in Brookhaven. Senator Barrett's familiar with this. And so this method actually goes back, Mr. Chairman, for 2019. Technology has given the thieves an easy way to do this because all of us have car keys now that we don't insert into a car door or the ignition for the most part. So they go and find as many keys as they can. They dump them in a pile, literally start going through them, clicking the button. So the lights come on a Dodge Charger. Bam, that's it. So then they have, that these are planned out. A lot of times they have the wire cutters to cut a big chain. So dealers are obviously trying to take whatever mitigation efforts they can to stop this, but it's truly a problem, and I won't bore the committee with it, but I have a whole stack of notices we send out to our membership because it seems like when it happens, they go back, and this last year was 3 nights in a row. We had Homeland Security, text Commissioner Tyndall, and on it. So it's a real problem out there, not to mention the individual car thefts that are going on, such as our Lieutenant Governor. So thank you, Mr. Chairman.
I appreciate your patience. I know you've been to a couple of our meetings, and we appreciate you hanging with us. Oh, always informative here. Yes. All right, Senator Hill.
Just want to add to his comments that a year or so ago at the Dodge dealership in Picayune, the showroom windows were busted out and a Hellcat was stolen out of there. And if the information I got correctly, when they finally tracked it down, it was on a ship in the middle of the Gulf.
All right. Well, with that, we had one additional bill, but I think Chairman Simmons obviously has detained another committee meeting, so we will get to that one. There'll probably be a couple of others for cleanup purposes that we have to maybe meet on tomorrow. We'll get with Ms. Pat to figure out a time for that. But thank you all for your patience and your help. And with that, we'll do.
Can I make one more quick comment? Can I make one?
Yeah, Senator Hill.
While Marty's still here, and you represent the home builders, correct? No, you don't. You don't represent the home builders anymore. Well, I wanted to say with what Suber did with the trespassing and hunting on public property, I've had a bill for a long time about strengthening trespassing on construction sites. And that's something that I would want the committee to look at down the road because we have so many copper thefts, appliance thefts, and trespassing on construction sites I think would deter that if we'd strengthen that. Thank you. Rise and report.
All right.